Hi, everybody. I'm Ravani Mudli. I'm the director for the Tech Transfer Office here at Innovis. We're in 15 De Beers Street. So if anybody's wanting to visit us, please come visit. On the line as well, I've got Ian. Ian, if you'll introduce yourself.
Sorry, missed the mute button. Hi, I'm Jan van Zyl. I'm a technology transfer specialist with Innovis, and background is engineering, so I'm focusing on the engineering faculty and also the hard sciences or any technologies that are coming out of those through research.
Thanks, Ian. So Ian and I just want to chat to you guys a little bit about commercialization of technologies, how your research can be used and commercialized, and the kind of processes that we go through here at the Tech Transfer Office. So I'm just going to share my screen now. Let's see if I can put it into presentation mode. Okay, can everybody see my screen?
Yes, we can.
Yep, can see it.
Okay, great. Okay, guys, so yeah, today we want to talk. I'm so sorry, I can't see anybody now. I can only see my screen. So please feel free to interrupt me. I can take a question during the presentation, or if you want any clarification, please feel free to stop me. Okay, so technology transfer, commercialization, and research impact. This is what we want to talk to you a little bit about today. So these days, academics, researchers at universities face a very different environment than it was many years ago. In the past, it was publish or perish. These days, there are many more pathways to achieve the impact that you want to achieve with the research that you're doing. So very much as it was in the past, universities and other research institutions are where we create knowledge. We invent, we first understand the problem, define it, and look at how we can solve the problem. So the actual creation of knowledge within our research is what we do primarily at university and have been doing for a few hundred years. I think some of the oldest universities are 800, 900 years old that are still going, and even before that, there were some universities. So the whole creation of knowledge within universities is something that we have a huge, long tradition around. And this is something that we take very seriously, and it's always been a very important part of an academic's life to create and then share that knowledge. Now, this is where things are starting to get a little bit more complicated, where in the past, the traditional way that academics shared knowledge was through publishing in academic journals, getting out that peer-reviewed information, having it critiqued, having it debated amongst other academics. However, recently, in the since the 80s, technology transfer has become a different mode wherein knowledge has been shared. This is where, instead of going directly to publishing, we can first protect the information, protect the knowledge, utilize intellectual property protection mechanisms like patents to first protect the commercial case and then publish the knowledge. Now, the thing about protecting it is that it gives you the opportunity to commercialize. Technologies that are not protected by patent and disclosed into the public are very difficult to create a commercial case because everybody can access and utilize that knowledge in the same way. So it becomes very difficult for any one company to go and invest in actually commercializing that technology. So therefore, from our perspective, technology transfer and knowledge transfer has to be considered very carefully because this is where we start making the connections between who wants to use the knowledge and how best to transfer that knowledge to them. Should it be in a publication, or should it be through some kind of commercial arrangement that will allow for a product or service to enter the market? So it's those types of questions that we here in the Technology Transfer Office can help you to unpack and understand. So we're really looking to connect between what we have as knowledge and what that knowledge can do and the impact that we can achieve with that knowledge. So in order for us to ultimately achieve impact, it has to progress beyond technology transfer into technology diffusion. And technology diffusion is where the knowledge is actually being used by society, and that is how we achieve either economic, social, or environmental impacts. Importantly, we must recognize that as much as we want to achieve impact as the final step, all the earlier steps that we took actually impact how we achieve this impact and what impact can be achieved. So it's very important for us to think about, okay, where did we receive the grant from? What are the conditions of the grant regarding intellectual property protection and commercialization? If we choose to partner with a commercial partner, what are the terms they expect? How will that technology move to poorer parts of society or low-income households? Would they be able to access this technology if we choose to partner with this particular partner? So those are the kinds of questions we need to start unpacking to determine what kind of impact we want to achieve, and then to choose the right pathway to impact. So here at the Technology Transfer Office, these are the things that we can help you with. Okay, so just to define again, technology transfer is the middle block. This is where we really help to connect supply and demand. So technology transfer is often referred to as putting information to use, or more specifically, moving ideas from the laboratory to the market. Technology diffusion, which is where you really want to see impact. Diffusion, on the other hand, it is the means by which innovations are translated into economic and social benefits. And that's from the Oxford Handbook on Innovation. So from a university environment, we often think about doing research, but the next step is innovation. So Jeffrey Nicholson, the guy who invented 3M, apparently said that research is the transformation of money into knowledge, and innovation is the transformation of knowledge into money. So this is where we want to help you. And we want to help you by understanding and preserving the commercial opportunity. So in order for us to help you to do that, we need researchers to keep excellent research records and laboratory books, because this is the source of your intellectual property. Then from that, we can determine what's the best way to protect the intellectual property so that we can preserve that commercial opportunity and maximize that commercial opportunity. And then we use different forms of intellectual property protection like patents, copyrights, trade secrets, and trademarks. Now, in the next part of the talk, Ian's going to go more into detail on that. So we really need for you guys to talk to the Tech Transfer Office team. Come and talk to us about your research, talk to us about the invention that is coming out through your research, or talk to us about what kind of impact you want to achieve. And we can look at different partnerships that can be organized to assist you to achieve that impact. Okay, come and disclose to us about your intellectual property so that we can find that suitable pathway. And then we also want you to know that this Stellenbosch University IP policy ensures that the benefits of commercialization are shared with contributors and enablers. Sorry, that's a spelling mistake. So our policy allows for any royalties or license fees that are received from commercialization of the intellectual property is then shared with the inventors and with the department. In that way, we would really want to encourage and promote creative thinking and commercialization of university research. Okay, I'm going to stop here and just check. Is there anything that anyone has a question about? I can see screens now. Is there anything that you would like to pick up at this stage? Okay, no. Okay. I'm going to go back now to the presentation. Right. Okay. So once you disclose your idea, you do an invention disclosure. You can find the forms at our website. It's innovis.co.za, and there is a technology transfer box on the landing page. And when you go into it, you will be able to find our disclosure forms, the IP policy, meet the team. You can also even request a meeting online. So take a look at our website. It's got lots of information, and you can use it to reach out to us as well. So from the research aspect, you're going to come into us and tell us about your invention or your technology. Once we've received that, we then do an evaluation. We look at what is the prior art, what is the other work in this field that is relevant. Is this novel? Can we protect it? Is there a reason to file a patent on it? You would file a patent if it's novel, it's non-obvious, and has industrial applicability. But there also has to, beyond industrial applicability, is there a market that's available? A patent is only viable, or has a time frame that it can be exercised on, and that is usually 20 years. So if the market is so far ahead, and if you're going to protect now, and the market is only going to develop in another 16 years' time, there's very little value in filing a patent now. So it's very important to understand whether or not the technology does have a market demand at the moment, and whether it would have one in the near future. So those are the kinds of evaluations that we're looking at helping you with. We also look at competitors and where the actual opportunity for the technology in the market is. From that, we can then decide the appropriate form of intellectual property protection. And then we look at investigating commercialization opportunities. Is it something we want to hang on with? It's something that's still so early. We need to probably do more research. It's something we might not have enough funding for, and we might need to do collaborative research with other universities, often international partnerships. Is it something that we could use as a technology or a consultancy services immediately? So those are the kind of commercial opportunities we also look at. Once we've got a sense of what the opportunity is, we start reaching out to industry partners. If we're going to do that, we sign a non-disclosure agreement, and we start looking at what kind of opportunities this would present. Is this something that is better licensed to a company that is already existing? Is it something that requires a huge amount of infrastructure or a huge distribution network that is better serviced by a company that is already existing? Or is this a technology that is better suited to a spin-off or a startup, a small company that is agile, that can go out into the market, try various new products, try various new markets, and be able to scale quite quickly? So based on the technology, we can actually then decide what is the best way to take this technology forward into commercialization. And this is the sort of process that we in the Tech Transfer Office help you with. Okay. Beyond that, we work with various other departments within Innovis. So we're the Tech Transfer Office. We also have University of Stellenbosch Enterprises. This is the holding company where all our spin-off companies reside. We also work with Launch Lab, and Launch Lab is our incubator. You might have visited it. It's out in Hammond's Hunt Road near the Decanting Building. So you'd find lots of exciting things happening there. You'd also find that a lot of the existing spin-out companies are housed in the Launch Lab, and there's always interesting talks, interesting events happening there. So if you haven't been there, I would suggest you take a walk out there and see what's happening. Suncom is the other commercialization arm for Stellenbosch University, and this is where lots of the bricks and mortar commercialization happens. We help with the patents and the intellectual property commercialization. Suncom does the commercialization of everything else from parking to the tenants at the NLC and various other commercialization activities. All of this falls under our Chief Director, Anita now. So within the suite of different departments, we can provide an end-to-end service on helping commercialization of various activities. Now, regarding specifically commercialization of research and technologies emerging from research, we're often using the spin-out method. Ian's going to tell you a little bit more about the spin-out companies, but if you want to take a look at how we've set up spin-out companies, you can go out to our website and there is a spin-out information guide. You'll find lots of interesting information there. There's also the Instant Startup Toolkit. I'm going to show you a little bit more about that. This is really a fantastic tool to help you unpack your technology, understand its different dimensions, understand and build the value proposition of the startup, and then look at how you're going to build this company. Another interesting program that we offer is the Translational Fellow Program. This has been offered previously to PhD students who have completed or master's students who have completed. Once their research is done, and in the next year, there might be an opportunity to do some pilot investigations, work with companies, do some samples, get some pilot results back so that you can actually establish the commercial case. You can then license the technology out to an industry partner, or you might find that you actually want to start a spin-out company. So this Translational Fellow Program gives you a stipend, and if you are permitted to be hosted by the department you're in, then you're able to actually de-risk some of the issues that might have emerged whilst you were doing your research, might help you to develop the business case around the technology that you've developed. Okay, the other partner we work with is the Stellenbosch Network. And this is a network that's connecting entrepreneurs, government institutions, academia, and industry around the Stellenbosch area. So also a fantastic network for you to look at. They sponsor a number of programs, a number of training programs. So really worth looking at the initiatives they're assisting with. So we also provide assistance in seeking funding. And these are some of the funding partners we tap on to help move technologies from a low technology readiness level to a higher technology readiness level so that it's easier to enter the market. All right, these are the platforms we've spoken about. And now I'm going to play a little bit of a video about the Instant Startup. Guys, are you all seeing it? Is it working?
We saw it, but I couldn't hear the sound.
Guys, I'm going to send the link. I'm going to send the link into the chat just now. I think I am either not sharing this properly or there is a problem. For some reason, it's not sharing properly. I will pop the link into the chat box just now. Let me just rather return to the presentation. No, now it's doing something else. Sorry. Okay, so the Instant Startup is a fantastic online platform that will be able to help you in actually building your business and unpacking your ideas, understanding the revenue models that you'll need to follow, understanding what is the specific value proposition that you're offering to a specific client. So we often use this to help spin outs to build up their business proposition. Now, my screen has stopped working. Okay, right. The other way that we can help you in marketing our technologies, especially technologies that need industrial partners and are not really suitable for a spin-out route, we use a platform called InPart. This is a UK-based company, and they help us to host a lot of our technology information blurbs so that we can market technologies to companies across the world. What we find is that many of the technologies that are coming out of our university don't always have natural industrial partners in South Africa. Often the biotech industries are overseas, or the companies that are willing to take risks in developing these technologies further need to have deep pockets. And many of these companies are situated overseas. The InPart platform allows us to market to a wide variety of companies. They help by matchmaking some of our technologies to industry partners. So it's been very, very useful. We've been using this platform for over a year now. This is a heat map of the hits that we get on our technology, on our technologies, and it shows you the kind of companies that are looking at our technologies and where in the world they're based. We often get emails asking for follow-up meetings where we discuss the technology and go into the details of the technologies with research companies or industrial partners who are interested in licensing the technology. Another way that we're looking at commercializing Stellenbosch University technologies is to start looking at the Faculty of Arts and Social Sciences. Increasingly in international universities, questionnaires, artworks, performances are all being seen as rich sources of commercial opportunities for the universities. So we're starting to have discussions with the Faculty of Arts and Social Sciences. We need to get a better understanding of what the opportunities are. We're starting to have regular meetings with some of the researchers to understand where we can assist them and what kind of markets we need to get their products into. So it's a bit of a learning opportunity for us because we have been working very much with sciences, engineering, medical sciences, and agri-sciences. Now we're starting to understand the value propositions from the Faculty of Arts and Social Sciences. Okay, another opportunity that we'd really like to discuss with you guys is commercializing of research tools and academic tools. So often in your labs during your research, you would have found ways to make your research a lot easier or to make your lab life a lot easier. These kinds of tools that you may have developed just for your team might actually have application with other research labs as well. And sometimes if these are packaged effectively, we can commercialize these tools. Many of the large international universities are doing this. And by commercializing the research tools, you're talking to an audience that is already knowledgeable about that science and can easily absorb that technology into their labs. And they often also provide you with feedback on how to develop that tool. It also allows you to make some research funds for your team. Okay, so basically as a technology transfer office, we receive about 25 to 35 disclosures a year. Currently, we have something like 300 patents on our portfolio. About 166 of those are South African patents. We have about 20 licenses which are currently paying us royalties or license fees annually. And we share the benefits of this commercialization with the inventors. We have established between 2 to 6 spin-off companies annually, and we track jobs created, the sustainable development goals that are supported by those companies, the investment raised, revenue earned, and dividends paid. Now, Ian's going to tell you more about those companies. But basically, from our perspective as the Technology Transfer Office, we want to help you to achieve the impact that you envisaged when you started your research journey. So we'd really like to talk to you about it and look at how we can assist you on that. I'm going to end the presentation now, and I'm going to go back to Teams. What I really want to leave by saying is that this is the time when everybody's submitting dissertations, everybody's getting to round up the year. What we'd really like to do is before you submit your dissertations for publication, please think about disclosing to us. We can assist you with protecting the IP or looking at commercial opportunities before the IP is disclosed and published. Once it's published, it's very difficult to go back and develop the patent, or it's impossible to actually develop a patent around that because there's no novelty anymore. So for us to preserve that commercial opportunity, we need to protect the IP before you actually publish. So yeah, looking forward to listening to as many people as possible who would like to do disclosures and to look at opportunities to commercialize your research. Any questions? No questions? Ian, I think it's over to you then.
All right. Great stuff. Please also feel to stop me at any point if anybody has any questions surrounding the intellectual property protection or anything that I may speak about surrounding the companies. If I can answer, I will. If I can't answer, somebody else will probably be able to. So that's it. Let me just share. Yeah. Right. All right. So we're just going to look at intellectual property with a bit of a commercial perspective. But first, let's just maybe speak on what is intellectual property? Intellectual property refers to the creation of the mind, and a creation that is then protected either by law or that is not protected by law, but that could be protected through confidential means. So that's where we have statutory and non-statutory intellectual property. I think something to take into consideration is that with IP, it's not an idea by itself does not constitute IP. Only once it's translated into a different medium does it become intellectual property. So once it's written down, once it's drawn out, once there's a way of remanufacturing it in some shape or form, once it's translated basically from just an idea in your mind to an actual medium where it can be communicated to somebody else, that's when it becomes intellectual asset or capital. From the statutory protection side, there's a couple of things, and there's a couple of methods where you can protect your intellectual property. We've got patents. Of course, patents is basically a monopoly that is granted based off of a full public disclosure of the idea. So with a patent document, once you've filed for a patent and it gets published, everybody would know how to replicate that thing. But because you have decided to disclose it, you get a 20-year monopoly to avoid it's a negative right. So you can restrict anybody else from utilizing it and from using it in any way, apart from usually from research, but you can usually research on the idea, but in terms of commercial aspects, you cannot infringe in that sense. There's a couple of things that a patent needs to fulfill. There has to be novelty. It has to be new. It has to be inventive. There is an inventive step, and it should be non-obvious to a person skilled in the art. And then, of course, the duration is 20 years. With patents, it's a territorial right, so every nation has a different way of doing it. But there is something called the PCT, or the Patent Corporate Treaty, where countries are signed up to, and basically you can protect internationally with much less admin. Instead of filing on the same day in all jurisdictions where you would want to file through a PCT, you can still do that, but you've got different timelines and a bit more leeway, and you also get some examination back on the idea itself to know if there would be local examiners that might have any issues with the patents. And examining, South Africa is not an examining authority. We don't look at you can technically get a patent on the wheel in South Africa, but but in the courts you wouldn't be able to defend it. So it is already disclosed public knowledge. But that's why some jurisdictions like the US, they're an examining territory. They would actually go and look at what has been filed in the past, and if there's anything similar, and if there is something similar, they would actually flag it. So just maybe something to keep in mind from a South African point of view. When you file locally, it's actually quite easy to protect or to get a provisional patent. Whether that would stand in terms of international examination, that's a different question. But usually we try and do a prior art search once we've received a disclosure from a researcher, and that usually guides our decision making on that. Although you can't always be certain that you catch everything, but it is something that we try and do. There are a few jurisdictions that also allow for design registrations. In South Africa specifically, we do allow for this. I think in the US, it's called a design patent. And then there's a few other jurisdictions that also allow it. But basically, a design registration in South Africa falls into two categories: an aesthetical design or a functional design. So aesthetical being the look of the thing, or functional being the function of the thing is inherent in its design, and that is what needs to be protected. And it has to be an industrially produced article. There's a grace period of 6 months for a design. So let's say you've designed a mechanism to fulfill a specific function, and the function is inherent in the design, and you want to register it. You can actually disclose that, but you would have to file a design registration within 6 months. There is a bit of a grace period with that. With patents, if you've disclosed it prior to filing, there's no grace usually. So there might be some territories where you could possibly get away with it, but most likely you wouldn't have any grace with designs. There are grace periods. Then there's plant breeders' rights. I'm not going to go too much into that, but that's basically a new plant varieties that are bred. Then trademarks. So trademarks are an interesting one. Trademarks, the time. Oh, sorry, I didn't mention this. On designs, you have a 10 to a 15 year, depending on which one you go for. You've got 10 years or 15 years of protection. With trademarks you can actually have an indefinite amount of protection. So in terms of timeline, so Coca-Cola is trademarked, it will probably remain trademarked, but it's also it's probably the most valuable trademark in the world. Trademark is there to distinguish the goods or services, and it protects you from something that would likely cause deception. So it's also open to a court of law to decide whether something is similar, but somebody can't just steal your name and your logo exactly and then try and say it's their mark. Sometimes you can get a trademark inherently from the use of a name where you intend a trademark. You will see if there's something that has a name, let's say Coca-Cola, you will see a little R in a circle. You'll know that that means a registered trademark. But sometimes you'll just see a TM in the right upper corner. TM means an implied trademark. It doesn't mean it's been granted or registered. Domain names will fall under trademarks and copyrights, but basically it's in today's world we've got domains that are which is your online gateway into the world. So those fall under either trademark or copyright. And then with copyrights, you've got copyrights, you don't have to file anything. It's an automatic inherent right for an author, and it's usually 50 years. Or yeah, that's basically it. We don't really file anything surrounding that. With trademarks, we file designs, patents, of course, and plant breeders' rights. We file, and then with the territorial rights, just understand that all the jurisdictions are not the same when it comes to trademarks or designs. Not all of them have designs, and then their patents, some are examining territories, some are non-examining territories. Non-statutory intellectual assets. So now we've discussed those that are registered and formal. Non-statutory intellectual assets, and this is sometimes the thing that really distinguishes companies or research units even, is trade secrets, confidential information, and know-how. Trade secrets could be the KFC recipe that was disclosed the other day in an article, funnily enough, and then there is the Coca-Cola recipe, things like that. Confidential information also, you could think of the weapons industry in that sense. And then know-how, just learning from experience, having done things numerous times and learning how to do it in a more better and a more efficient way. That also constitutes some form of intellectual asset. But once it's disclosed and another party becomes privy to it, the problem is then all of this falls away. So this needs to be protected by other means, by contracting or by non-disclosures or by certain company policies that are put in place if it's for employees not to give out trade secrets, or just by strategic protection through that only certain people know certain parts of whatever that trade secret or confidential information is. So when it comes to how this rolls out in business, and I maybe need to take a step back. Okay, I'll deal with the IP when we get to the company side. Sorry, let me just finish this first. So for businesses to be successful, it's usually you have your business environment, you have your technological environment, and your legal environment, and then where all of those cross paths, usually you've got intellectual property that is bred out of all of that, because you've got your technology, you've got your business side of things, you've got your law side of things, and your intellectual property at the end of the day gives you that competitive advantage when you know in what kind of regulatory framework are you operating, you know how the business world is functioning, you know how your market specifically is functioning, and you've got a technology that you're offering in that market and it's being adapted all the time. And usually that is the beautiful thing about IP. It can protect your position in the market, and at the end of the day, if a business is not competitive, it's not going to survive. So there needs to be a certain amount of intellectual property in any business for it to survive. And it's not always as straightforward of what you think. It's not that Tesla is a vehicle company, but it's probably that it's a data driven company. It's not always Amazon is not a book selling company. It's not always the thing that meets the eye. It's actually what's going on behind closed doors and how the company is strategic about it. So there's always IP generated in that sense. And this is also something that distinguishes companies. I'm going to skip that one. I'll come back to that slide later. On the company side, so we've got a company called GeoSmart. They focus on geospatial information, but most of their intellectual property is non-statutory. Actually, most of the data that they also give to clients is actually open source and available, but clients do not know where to get the data. Clients do not know how to source the data in a timeous fashion. And then what GeoSmart does, it simplifies that for clients, and they can then buy these different products. Of course, there's also algorithms that's been developed so that there are newer products that come out, but all these things are non-statutory IP. It's not that there's a patent on which GeoSmart is based, but this is a spin-out company formed out of a university, out of research. But basically, the researchers here are experts in the field. They've got networks. They understand how the system fits together, and they can leverage that intellectual property that they have for this company to be competitive and successful. And as the company grows and does more business, they will develop further products, which they are currently doing, and they are developing further algorithms to give them a further competitive edge and give better value to their clients. Whilst doing so, they are generating new intellectual property, and it further strengthens their position in the market, which is great. So a company doesn't have to be based on a patent. Definitely not. You also don't need a patent to start a spin-out company at the university, but there is some competitive advantage that needs to be identified. There needs to be some form of competitive aspect, and that's usually in the form of intellectual property. It is just not necessarily statutory IP. It could be non-statutory. It doesn't have to be registered IP, and that is something to keep in mind. But of course, if the information is published and it is very well known, then that probably negates the need to go into the market, because anybody else can become your competition if everything is disclosed. So there's also always some form of know-how or trade secret that needs to be kept back, or that needs to be kept confidential for a company to remain competitive. No company goes out and discloses everything they do, the way they do it, exactly how they do it, because that'll mean the end of the salaries for the employees. It'll be the end of the value for the shareholders. It'll also be the end, of the market competition, and then competition will basically drive it just to a price war, and then you'll kind of have a saturated market. So one of the companies that is based on statutory IP is the Stellenbosch nanofiber company. This company actually they do have quite a bit of patents. They also started out as patents. I believe it's the first PCT that Stellenbosch filed back in the day. So this is based on nanofiber technology and spinning nanofibers, and the product and technology developed from research, and it was protected because the researcher had a eureka moment where they were able to spin nanofibers, and then as they developed and did further product development, they actually developed an even better process with bubble spinning, and they have now they're a complete company. They develop solutions for quite a few companies that require nanofiber. One of them is Squin. For their facial products, they do nano pillows based on their fiber technology, because there are, of course, other advantages. But this company's competitive advantage is secured through the statutory IP, through the filings, also in foreign countries where they've got patents based on their technology. But of course, with the researchers, there's a lot of research that still had to happen. So sorry, I can't see anything. So if somebody wants to stop me or ask a question, you're welcome just to interrupt me. Based on the IP that they have, if the patent is filed, they could still publish, they could still do research from the researcher's point of view. But now they retain the competitive advantage in the market because it's already protected, even though it's disclosed. It was protected first, and then it was disclosed. And this is something that researchers can keep in mind, that if you need to publish, if you need to do an article, IP wouldn't stop that. And the intention is never that a statutory IP should stop that. The only thing that it would stop is non-statutory IP that is going to go out. But usually that's at the discretion of the researcher, depending on how much they want to disclose in the article. But when it comes to statutory IP, you could file a patent, and the next day from the filing date, you could actually go into disclosing into a journal. You could write an article about it. So the IP side of things is just about protecting it. If there is economic value, if there is further value that could be added to it, if that is what the researcher really feels, disclose it to us at the TTO, and we will help you to protect it. We'll go through the process with you. And then, of course, you can still publish, because we understand you have to publish, but then the IP gives us the benefit that there could be further impact down the line. And it really just protects the position of where that technology is once you get to that point. And especially with new novel research in niche applications, there's always the opportunity that you could run into a great idea, a technology that changes that specific segment of the market. And you'd rather want to have that protected, because forming a spin-out company is, of course, not the only way to get value from the intellectual property, but you could do it through licensing. And you didn't have to even be involved in the licensing, in a sense, because you could just advise the TTO. You could sit with the TTO to write a tech transfer pack, basically, or a technology pack, and that can be licensed out to other companies that exploit the technology commercially, and royalties would be received based on that. So there are other methods. You don't just have to start a company, but there are certainly advantages in having registered IP, especially if you want to disclose and write articles. It's better to disclose it to the TTO, have it ring fenced, have it registered, knowing that it's protected, and then disclosing, instead of disclosing it and looking back and say, oh, I should have, because now other companies can run with it, and other companies that are maybe well developed, well positioned to exploit it, and then you wouldn't be able to catch up. So the idea is to have the registered IP, and that puts the onus on whatever the market segment is, or wherever the research is that you are doing. It puts the onus on those companies to approach the university for a license, or in-house, if you decide that this should become a spin-out company, then that road can also be taken. And then that also protects your market position as a very small company, because technically what patents specifically would do, it gives you the David and Goliath strategy. It protects your market position, and it helps you to fight and to compete with the bigger companies out there. Just as an overview, the Stellenbosch University has got about, this is not the updated one, but there's about 32 spin-out companies currently, and you'll see it started in 1998. In 2014, you'll see the Launch Lab was created. The Launch Lab, most of you will be familiar, behind the engineering building, and since then it has been the active incubator, and you can see the explosion of spin-out companies that have since formed, because it was a very big value addition to the innovation ecosystem at the university. And the Launch Lab is where we help researchers hone their entrepreneurial skills, look at their business cases, also incubate them, set up networks, all the rest. And this is a great help to our companies in giving them a head start in the world of business, because we've run through this quite a few times. And like Ravani showed, there is the spin-out company guide. So definitely look out to download the PDF, read through it. Then you know what to expect when starting a company with the university, if that is something that you intend to do. But it's really great to see the companies that are growing. They are receiving investment. They are employing students. They're employing postdocs. They're employing people. And as they grow, of course, they become completely self-sufficient. And that's really, that's really wonderful. just on the IP side of things, for all these businesses that you see here, you could see logos immediately. You've got trademarks already. And then each of them doing development. Some of them are based on patents, some of them are based on research that's not necessarily patented, but because there's a highly specialized skill that's been honed over time, they can be competitive in the marketplace. And then, of course, they will develop further. They'll develop non-statutory IP like trade secrets and confidential information that gives them the competitive edge. So IP helps you to, of course, do your brand building. It'll underscore your innovation culture. So basically, innovation is happening. It also gives you a very good repertoire with, let's say, venture capital, with investors that want to invest. Intellectual property gives investors a sense of security, because intellectual property is something like physical property in the sense that you can take a loan out against it if it's valuated. It is something that puts value inside of a company. So this is something to keep in mind. Of course, it shows that your company has technological leadership, and it also protects your place in the market through ownership. Then, on a strategic value level, I think we've spoken a lot about this, but there's licensing that you can do to third parties from a company's perspective and from the university's perspective. There's a lot of further. A lot more that we can say about this. I don't want to bore you too much with the details, but of course, it can improve your negotiation position with other companies, or it can improve your negotiation with various other parties. But at the end of the day, intellectual property registered early won't impede your publications, your research, and it will help you if in the future you decide to try and capitalize on what you've done, on the research work. Because what we've seen a lot of researchers develop an idea, it's early stage, it's protected, and then they continue with the research, and maybe 2 or 3 years down the line, they're like, you know what, I really want to take this idea forward. And then the opportunity is there because it's already registered. Some of the technologies we've licensed 12 years after the fact. So it was 12 years registered and only has been licensed recently, and that's still creating value. So there's that is the fun part around intellectual property, especially patents. I mean, it gives you a 20-year opportunity to actually capitalize on the technology. So yeah, definitely keep that in mind. Decide to use IP for the benefit of your research and future endeavors. At the end of the day, positions you uniquely as a researcher, showing that you're an authority in the field with patents, as well as you can publish as you please. And then with future endeavors, I mean, you'll have great impact. And I think impact is what it's all about. And a company that employs people, that feeds families, give great impact. So yeah, that's all from my side. Any questions?
Hi,
there's no questions.
Yeah, it doesn't look like this. Sinazo,
like
from your side, any questions? Anything from a DRD perspective?
Everything was clear from my side.
Okay, great.
Thank you. Okay.
Okay.
There's a hand. We have a hand.
Okay, great. Go ahead, Prof. Pasquita.
Hi there. Thank you so much for presenting. I have a question about work that we're doing in the public space. So it's not for profit, but it's still IP that I would like to protect. Do we work through Inerfus, or how is it, or is it NDA that will then be sufficient?
Yeah, definitely work through us. You can we can send you a disclosure form, and we can set up a meeting. What department are you in, Prof?
I'm in the Department of Logistics.
Okay, great. And then we can take it from there. We can look at the disclosure and look at what's the best way to protect it. Your intention would be to look at a spin-out company, or what would you be thinking about?
It's a decision support tool that we're developing in collaboration with doctors. So it is something that I would like to protect because I would like it to be used in the public healthcare space. So I'm not sure if it's a company or what then I'm actually I have no idea. I haven't done this before, so I'd actually just want some advice on how to think about it and how to proceed with it.
Okay, great. Maybe we can have a meeting with you, chat about it, and then we can decide whether to fill out the disclosure or what might be the best way to actually protect this. And then you basically want to see it having impact, that as many people who need it can use it.
Yes. So it's less for profit, but it's something that I think would be very useful.
Okay, no, great. We'll set up a meeting and then we can take it from there.
Thank you.
Ian, from your side, any comment on this one?
Yeah, I think we basically would need to find out, what is known, what is not known, and I think then decide, especially if there's a clear intention that this could be a public benefit thing. So yeah, I think just get an overall view of where it is, how it was conceived, and where it's going, kind of like a normal disclosure, and yeah, then we can advise on that.
Okay. Any other questions? No. So please take a look at our website. I'll put the website address into the chat box as well. And yeah, we'd be very, very happy to have conversations. Meet us for a cup of coffee over at the Launch Lab. Come over to our office. We're very, very excited to hear about what are the PhDs going out this year, what are the master's dissertations that are going out. Is there anything we can work with? So please come chat to us. And that's it. Thanks, everybody. Thank you for your time.
Thanks everyone. Thanks. Bye-bye.